Let's take you back to the High Court in Pretoria. That's where 13 people implicated in the VBS scandal are making an appearance as part of their pre-trial hearing. Let's listen in.
A magistrate and obtained a search and seizure warrant to obtain all documentation in other words, everything that Werksmans did in the course of its responsibilities to the South African Reserve Bank, it requested all those documents. Well, by virtue of a search and seizure warrant. It was granted a search and seizure warrant, and it obtained all this information. And the request from his superiors was authorized that Werksmans assist it in the continuation of the investigation. Now, my instructing attorney, as instructed by my clients, specifically requested the procurement documents in that regard, the procurement processes that was followed in that regard, and everyone that was involved. And what this really hinges on, it hinges on the propriety of the investigation, and which my clients have made it plain they intend attacking. They intend challenging the propriety of the investigation, and that goes at the heart of the charges that are preferred against them. Now, we've specifically requested those documents. The state writes back, if I remember correctly, I think it was a PAJA application. And yes, it was a PAJA application. I beg your pardon? Not a PAJA. It was a PAJA application, yes. They responded and said, well, we cannot give it to you. There are two grounds why we can't give it to you. One,
you mean the first respondents?
I'm getting to that. We're still with the police. We're still with the police. The police responds and says, well, we reject your PAJA request. We do so on two grounds. The first ground is that in terms of PAJA, if the matter is the subject of criminal investigations, pending criminal investigations, you cannot get it. Secondly, if you wanted, apply for it in terms of the provisions of Section 87 of the Criminal Procedure Act when you submit your request for further particulars. I apologize. My clients, the applicants, are arrested in March 2021. They are provided with documentation, well, electronically constituting. Regrettably, I've got to relay the version to you so your Lordship can understand how we get to where we are. My clients are served with documentation electronically that constitutes some 160-some thousand pages. Of course, that grows exponentially and ultimately culminates to almost close to 200,000 documents. In July 2023, my clients, through the attorneys, submit requests for further particulars. That's correct. And in that application, these very documents are sought. The state says, we can't give it to you because we don't have it. The state does not say these documents are privileged. They do not say these documents will reveal state secrets. These documents will reveal the names or identities of informers.
And it's not so. The state does not have that information.
Well, the reason why I'm dealing with this is, with the greatest of respect, this is an issue your Lordship ought to have dealt with when your Lordship heard the original application.
No, it doesn't. It indicated in paper the state cannot provide with the information that it does not have.
Well, I will address His Lordship later on in greater detail on that to convince His Lordship otherwise. Henceforth, we submit.
Just before you proceed, is there any indictment which is based on the Cherimutau report here?
Well,
is there any case against two of your applicants which is based on the report by Terry Mutla?
It emanates from that. And perhaps, if your Lordship will indulge me for a few seconds. The first applicant in this matter was interviewed by Terry Matau and his team and Werksman in the course of that investigation. Now, the very people that interviewed him become the investigators for and on behalf of the police. Serious allegations are made in that report against the second applicant, which they subsequently had set aside, through the High Court as unlawful. Now, the propriety of the investigation is central to my client's rights. It's central to my client's fair trial rights. And anything and everything that emanated from the Matau investigations and from Werksmans who participated in that investigation, who led that investigation, and who subsequently continued that process with the SABC investigation, my clients question their propriety, and they need those documents to challenge the indictment, to challenge the charges against them.
So should I assume that your response then is that yes, some of the counts put against the first and second applicants are based on the report that Mutau SC presented?
My Lord, I'll go as far as say the entire investigation, the entire allegations against my client stems from the investigation conducted by Terry Matau SC and Werksmans. There's no allegation that's in the indictment. There's no factual basis that stems from the indictment that does not go back to that initial investigation by Terry Matau SC and Werksmans. It's on that basis that we seek this information in the protection of the applicant's rights. This goes at the heart of the indictment against my clients.
There is an allegation by the first respondent that the charges against the first and the subsequent are not based on Mutau's report. Did you notice that allegation?
My Lord, the issue is not whether it's based on that report. The issue with the greatest of respect is that I'm about to answer His Lordship. If Your Lordship would allow me, if Your Lordship would kindly indulge me, I'm happy to answer any and every question Your Lordship has. But we shouldn't be speaking over each other.
Did you see that allegation?
I've seen that.
You saw it.
I've seen that. May I answer that, my Lord?
Yeah, okay.
Thank you. The allegation may be that it's not based on the report. The evidence emanates in its totality from the Matau investigation. It's indisputable. It's indubitably so.
There's a difference in there.
Absolutely. Absolutely. Thank you, my Lord. Now, as we said, firstly, the state, of course, proclaimed that some of the documents, information is not in its possession, and hence, it cannot provide it. And then secondly, that the information is not in the docket and does not form part of what needs to be discovered by virtue of it not being in the docket. Of course, we have a different view, which we'll address His Lordship on later on. And Your Lordship, I'm just busy with my introductory remarks. I'm going to get into the meat of everything in due course, and if Your Lordship would indulge me, I'd be most appreciative. Your Lordship, the applicants have taken this court in its papers into complete confidence, and it's made it plain that the documents and information it seeks is intrinsically linked to further substantive applications that it wants to bring. The first application is, of course, to challenge the propriety of the investigation head on, which they are, in terms of the Constitution, enjoined to do. Secondly, is to challenge the charges in the indictment, to do so head on. And thirdly, is to challenge the racketeering certificate that was issued by the National Director of Public Prosecutions. Now, Your Lordship would recall that these are applications that can only be moved before the trial judge. And Your Lordship was only seized with this matter, or allocated this matter, on or about 28 September 2023. That's some months back. And Your Lordship would very well recall in that self-same case management meeting that Your Lordship's brother, the Honourable Deputy Judge President, DJ Pila Dwaba, directed that all applications be moved or brought before pleading, and of course, pertinently so, to limit and prevent any delays that may be occasioned to this trial, or to the commencement of this trial. And of course, DJ Pila Dwaba was quite mindful of the provisions of Section 35, subsection 3, subsection D of the Constitution, insofar as the possibility of any unreasonable delays that may arise as a result of any applications. Hence, the suggestion was that if there's any applications that must be brought, these should be brought before pleading. Notwithstanding, of course, the matter was set down for trial, notwithstanding my clients having filed an application for further particulars. This was refused by the state. They've asked for further and better particulars. It was refused. They then brought an application to compel, and that was refused, which, of course, Your Lordship had agreed with that judgment. With the position that the state had taken. Hence, that judgment has been taken on appeal. Your Lordship, my client's position is simply this: they cannot prepare for their defence. They cannot prepare for the presentation of their defence. And the prejudice, or let me rephrase that, the substantial prejudice that my clients are being subjected to remains continuous until the Court of Appeal, whether it be the Supreme Court of Appeal, whether it be the Constitutional Court, has had the last say on the matter. So,
just to make sure that the judge has allowed you, could you please just elaborate the procedure?
yes.
It has to be followed from the time you lodged your application. If the appeal is not procedure to be followed until how long that will be?
Perhaps if Your Lordship could just rephrase that. I understand Your Lordship requires a timeline. I just want to understand.
That is going to change. What is going to happen? You still haven't had anything from SE.
I'm now with His Lordship. I'm sorry. I at times cannot hear His Lordship well, and I of course will raise that with His Lordship. Your Lordship, perhaps if we go back, if I remember correctly, Your Lordship dismissed the application for leave to appeal on or about the 26th or 27th of was it June?
Never mind.
Yeah. So of course we try to get the court order, etc.
Especially
Yeah.
the application.
Absolutely. Now, that was only obtained some days before we actually filed our application at the Supreme Court of Appeal. So the application for leave to appeal was served in the registrar of the High Court on or about the 18th of July, and was filed with the Supreme Court of Appeal on the 19th of July, and we moved this application on the 22nd of July. But Your Lordship must look at the proximity of time and place. Your Lordship had dismissed the application for leave to appeal. There was endeavours to obtain the relevant orders and documents. Of course, then there was a guilty plea by Mr. Matotsi, and the process that it followed. Then we were served with an amended indictment, and I think it was done on the 13th. So Mr. Matotsi pleaded guilty on the 10th of July. There was the amended indictment was served on our clients on the 13th, Saturday the 13th of July. And of course, we then filed the application for leave to appeal with the registrar of this court on the 18th of July, and on the 19th of July we filed with the Supreme Court of Appeal, and the 22nd we moved this application.
The petition was moved on the 22nd of July.
No, my lord. This application was filed. So this application was filed on the 22nd of July. Now, we've heard that the petition was filed on the 19th of July with the Supreme Court of Appeal. As of date, my lord, we have heard nothing. We have not heard a single word.
Do you have any idea how long that's still going to take before you can get to?
My lord, experience has taught me that it will take a matter of months. By virtue of the court role and the matters that the Supreme Court of Appeal is seized with, that it will take a number of months before we receive some sort of response. And it's, ordinarily, it should be given first preference by virtue of of the urgency associated with it, and by virtue of the pending trial. They ought to be given preference. But I'm not in a position to speak on the processes at the Supreme Court of Appeal.
And what you are waiting for is leave to appeal to the SAB.
Absolutely, absolutely. We are waiting leave to appeal. Of course, if our application is favorable, we will probably then be given a date.
I'm sure Mr. Parliament will also say so about his case.
Yes. And and of course, whatever processes follow thereafter, the timeline, with the greatest of respect, is indeterminable. It's out of our hands.
So after supposing your application is successful, so you still have to get the date on which to argue the matter.
Absolutely.
And you don't know how long that is going to take.
We don't know, because heads of arguments will have to be filed. A date will be set for hearing. We'll then have to wait for the judgment, and that's indeterminable.
And as you indicated in your papers, if the judgment goes against you, you still want to appeal to the Constitutional Court.
Those are my instructions, my lord.
And you have no idea how long that is still going to take.
Absolutely, my lord. It's entirely out of our hands. And perhaps to add to that, my lord, my clients' further substantive applications, which they would like to bring, is intrinsically linked to the outcome of the appeal. They can't even move any of those applications until they have finality and the highest court has spoken on the matter.
And you say in your paper that you realize that it's going to cause prejudice to the co-accused.
Absolutely, my lord. Absolutely. From submissions made to this honourable court on the 22nd of July, and from submissions made by the 5th and 8th respondent, and my learned friend representing them, Mr. Stroh, it is evidently so that the accused, by and large, will be severely prejudiced and or substantially prejudiced should their trial not start soonest. And my understanding is all the other accused are ready to proceed, except for my clients.
Since last year.
Yeah. Except for my clients. And my clients is dependent on this process and this exercise to unfold, and their hands are literally tied behind their backs and their ankles, may I add, by virtue of a process that's indeterminable.
So under those circumstances, you feel that your second prayer would be the most convenient one to pray?
Absolutely, my lord. Absolutely.
The trial
if we succeed, if we succeed on the second prayer, the first prayer falls away entirely.
Mr. Stroh supports you in that regard. Did you hear anything from the other country?
My lord, Not at all. Aside from the submission made by my learned friend to say that they would abide.
The decision of the court.
It would have been very helpful, had the other accused,
respondent.
absolutely, had the remaining respondents filed papers in the matter, and/or heads of arguments, and/or whatever, just to articulate their position. But by and large, I think.
All right, so those are live visuals coming outside of the High Court in Pretoria. That's where the 13 accused in the VBS matter are making, I suppose, representations as part of the pre-trial proceedings. Essentially, the thrust of the argument being made there is that the investigation that led to them being implicated, at least one of the accused, was flawed, and therefore the charges themselves should be dropped.